Crime and punishment, deterrence and cost. Those are the key issues that confront voters when they go to the polls in November. Proposition 34 would eliminate the death penalty and make the maximum sentence life without the possibility of parole. Prop 36 would amend the state's three strikes law to require that before a life sentence is imposed, the third strike be for a serious or violent felony. Our guests have strong opinions on whether California's death penalty and three strikes law should be amended or not. They are Carl Adams, Sutter County District Attorney and President of the California District Attorneys Association; Ignacio Hernandez with the California Attorneys for Criminal Justice; and Helen Hutchison from the League of Women Voters of California. The death penalty and three strikes. The costs of crime and punishment.
From Fresno, the Maddy Report, with Executive Director of the Maddy Institute, Mark Kepler.
Welcome. Should the death penalty be replaced with a sentence of life without the possibility of parole? Our guest believes that the answer is yes. She is Helen Hutchison from the League of Women Voters. Welcome to the Maddy Report.
Thank you.
You know, voters have repeatedly rejected repealing the death penalty. What's new this time around?
So the current system is really broken beyond repair. Most death row inmates die of old age rather than being executed. Since 1967, only 13 people have been executed, and none have been executed since 2006.
And that's out of a population that I think I've read of over 900 people that had been convicted to death row,
right,
or sentenced to death row.
Right.
So that's a pretty small percentage.
Right. And besides that, it costs a lot more money. So we've got, most people think that the death penalty is cheaper than life without the possibility of parole. But
well, it would seem to be because the person's no longer in prison.
Right. But because of the mandated appeals that happen with a death penalty case, there's a huge expense there for all of the court costs and defending these people. And imprisoning somebody on death row is actually more expensive than in the general population. They don't work, they don't generate any income, and they have higher security, and they have higher, and they're all in single cells. My
understanding is that they always have to be accompanied by a prison guard if they leave the cell.
Yes.
So that adds to the cost, and that the average appeal is about 18 years.
Yes.
So it's a pretty long and lengthy process. I think I also read a statistic, and you can correct me if I'm wrong, but it costs an extra $90,000 per year over the cost of someone in the general population to house a death row inmate. Is that?
That is correct, yes.
Okay, so the numbers are fairly high. But still, even when you talk about those numbers, we're still talking about, when you talk about the state budget, a pretty small portion of the state budget. You know, the prison budget is $9 billion. Right. The LEO says that this provision could save anywhere from $100 to $130 million a year. Well, that's 1% of the prison budget.
But it also, this measure also mandates that for the first several years, that money is going to be set aside and used to help solve the backlog of current homicides and rape cases.
The unsolved.
All those unsolved cases. So there'll be a lot of money that will be done that. And you can solve a lot of crimes for that much
So
money.
The argument is that this is money better spent on solving crimes than putting someone allegedly to death who really never gets executed.
So currently less than half of murders are actually solved, 46%. And you have, and slightly over half the case of rapes, but I think 53 or 54% of rape cases are solved. So you have half the cases are currently going unsolved. Those people are out there and walking the streets still.
And you're thinking that if they put more money toward this, that those would be solved?
Right. At least some of them could be solved.
Okay. So, well, what about the argument that, you know, if you put someone in prison without the possibility of parole, you then have all this extra housing and health care costs as they get older. That's going to be pretty expensive. That's
we're paying it now. We're paying it now, and we're paying more than that amount now because these people are dying in prison rather than actually being executed.
So you're saying that the death penalty is a false promise?
I think it's a false promise, and it just, when you talk about victims, and victims' families, there is no justice in this interminable number of appeals and continually going back to court for all of these cases.
Well, what about the argument that, okay, then limit the number of appeals?
We have a problem with making sure that we don't execute an innocent person. And I know that people will say, well, we have never done that in California, but who knows? We don't know if we have ever executed somebody who's been innocent in California. We know that there are some people that have later been found to be innocent before they were executed.
Okay. The last thing I want to talk about is the number of murderers that actually end up on death row. The number is pretty small. It's about 2%. The reason for that is that there has to be a separate finding of what's called special circumstances. Doesn't that provide a safeguard to really limit the death penalty to those people who've done really heinous crimes?
We still are losing money by doing this. The victims and their families are not getting any sense of solution or resolution to this, and they really could be that money could be better spent if we lock them up and throw away the key. People that are currently serving life in prison without parole, those people are either still in prison or they've died in prison.
Yeah, I would wonder what people would say is which is the more difficult punishment, being put to death or being in prison and throwing away the key?
And I think that's a good question about that. So,
well, I want to thank you very much. This is Helen Hutchison with the League of Women Voters. When we come back, a response to those who oppose Prop 34 and want the death penalty to remain in place. That conversation in a moment. This is the Maddy Report. We're now joined by Carl Adams, Sutter County District Attorney and the longest-serving district attorney in California and president of the California District Attorneys Association. Welcome to the Maddy Report.
Thank you. Glad to be here.
Great. Well, listen, historically, one of the big criticisms of the death penalty has been the number of false convictions. There was a report put out by the Death Penalty Information Center, and it said that since 1973, 140 death row inmates nationwide have been exonerated while awaiting execution. What do you say to those who say that this is a mistake that can't be undone?
Well, to start with, Mark, the Death Penalty Information Center is not a criminal justice think tank of some sort. It's an anti-death penalty lobbying organization. There are no attorneys on their staff. There's not a prosecutor on their board of directors. And it leads to statements or phrases like false conviction. As a prosecutor, I don't know what that means. I don't know when you say false conviction if you're talking about someone who was sentenced to death, whose conviction was overturned because there was a procedural error in jury selection, or if you're talking about someone who was sentenced to death who was later found to be factually innocent and actually not commit the crime. In California, there has never been a person sentenced to death who was subsequently found to be factually innocent of the crime. Governor Jerry Brown, who opposes the death penalty, has said himself, there are no innocent people on death row.
Well, what about the argument that, human judgment, human error? It's innate.
It is innate. And because of that, the death penalty process in California involves the most careful scrutiny of the cases and of the trials that result. You look at the death penalty process in California. You start with a prosecutor who has to make a decision that the case is going to be pursued for the death penalty, which, by the way, automatically results in a second attorney being present for the defendant. You present the case to a jury. They have to find that there is a special circumstance, something factually unusual that justifies the death penalty, and they have to vote for it. It then goes to the trial judge for sentencing. The judge has to agree and impose the death penalty. And when that happens, there's an automatic appeal to the California Supreme Court for the whole thing to be reviewed. And even when the appeal is done, there's a lengthy process of writs and petitions and hearings, both in state court and in federal court, to test the factual background of the conviction and the procedures that were used during the trial.
But that's what some people are saying. They're saying that the death penalty really is a false promise, that in reality more people die of old age on death row than are ever executed.
They do. The system is broken now because of the extensive appeals and writs and petitions that are available that duplicate process, that litigate the same thing over again in federal court that has already been heard in state court. And because of that, the system should be changed, but the death penalty shouldn't be abolished.
Well, what about the question of the deterrent effect of death penalties? If the death penalty isn't being carried out, what is the deterrent effect? And wouldn't a life sentence without the possibility of parole be more of a deterrent than a death penalty that's not going to be implemented?
The deterrent effect is that the defendant in the case is sentenced to death. That has an impact. It has an impact on the community, it has an impact on criminal justice, and it has a tremendous impact on crime victims who feel that their crisis, their emotion has been dealt with in some fashion by the justice system in this state. The deterrent effect comes from the sentence of death. And life without possibility of parole is no guarantee either. As a matter of fact, if you remove the death penalty, and life without possibility of parole becomes the most serious result that can occur in a California court, one immediate effect is that you expose prison correctional officers to risk of assault by life prisoners, who now no longer have to worry about the death penalty.
One of the arguments that the proponents are making is that this really does a disservice to the families because of this. I think it's 18 years is a typical appeal process. That they're on a roller coaster of emotions at every hearing, waiting for for this person who's found guilty to be executed.
There aren't any victims who are supporting Proposition 34. The ACLU and the California trial lawyers who have broken the system and caused this anguish to the victims are the ones who are trying to abolish the death penalty. The victims groups are firmly in support of continuing the death penalty in California.
What about the argument? It seems to be the argument this time really is cost. That seems to be the major argument on the pro-34 side. They argue that the money could be better used to solve crimes than try to implement a death penalty.
The death penalty is the most serious step that a society can take in dealing with criminal behavior within the community. Heaven help us when we reach the point that that decision is being made on a cost basis. But every major law enforcement group in California opposes Proposition 34. They know that money is a fiction. The fund that has been written into Proposition 34 transfers money from the general fund. It takes budgetary discretion away from the legislature for $100 million and moves it into a special fund that law enforcement doesn't want and is not asking for.
Okay. Well, when we come back, thank you very much. When we come back, we'll talk about another law and order ballot measure, Prop 36, which would amend California's toughest in the nation three strikes law. That conversation in a moment. This is the Maddy Report. California has the nation's toughest three strikes law, but is it too draconian? Prop 36 would impose a life sentence only when the third strike is for a serious or violent felony, not any felony. We're now joined by Ignacio Hernandez with the California Attorneys for Criminal Justice, who supports Prop 36. Welcome to the Maddy Report.
Thank you for having me.
First off, who drafted Prop 36?
Prop 36 was drafted after a series of meetings and years of study by the Stanford University School of Law and also or professors there at the law school, as well as the NAACP Legal Defense Fund. And they reached out to prosecutors throughout California and investigated real-life cases to come up with what they thought was a moderate but important fix to the three strikes law that would, one, save $100 million for taxpayers and make sure that the worst crimes still receive very harsh and serious punishment.
You know, one of the criticisms of the current three strikes law is that the third strike can be for a non-serious or non-violent felony. But isn't it a felony nonetheless? And don't the first two strikes have to be serious and violent?
Yeah, that is true. And that's one of the most effective parts of this proposition, which is the third felony will receive a harsher penalty than it would under normal law.
How much harsher?
Well, it would be a double punishment. So if you have someone who had a serious or violent felony or two serious and violent felonies in their past, and then they commit a non-serious, non-violent felony under this proposition, they would receive double the penalty.
So in other words, if it had been a 10-year sentence, it moves up to 20 years.
Absolutely. So this proposition is still very, very harsh on someone who commits a third felony. But where it's helpful is it doesn't impose a life sentence for what we have been finding been very minor, non-serious, non-violent offenses, such as a very simple drug possession, where we're finding individuals getting essentially a life sentence for having a relapse after, maybe 10, 20 years of being crime-free.
You know, opponents say that this is going to give repeat offenders the opportunity to continue in their criminal activity. How do you respond to that?
Well, again, I think the opponents have misread the proposition, and what we're finding is that the way the bill is drafted, we will make sure that the punishment fits the crime, and if you have a prior history, you will have a longer sentence. And there is, the way it's drafted, not everyone will benefit under this proposition. So rapists, murderers, child molesters, they will not be able to take advantage of this proposition. And that's really what the original intent was of 3 strikes, was to get to those, the worst of the worst. So we preserve that. We make sure that the harsh punishments will stay in place, and we make sure that those individuals that shouldn't have access to this, the relief provided by this proposition, aren't provided that.
Okay, another criticism of the way the current 3 strikes law is being applied is that they say it varies from DA to DA. But don't you want some prosecutorial judgment and discretion in the process? And aren't DAs essentially elected by the people, and the people are electing these folks to exercise that judgment? Yeah,
that's a great question. Prop 36 preserves judicial discretion and prosecutorial discretion for the relief that is available. So we do value that discretion. But what we found is that the discretion has led to wildly disproportionate sentences. So you may have someone in one courtroom receiving a 10-year sentence, and someone in the courtroom right next door is getting essentially a life sentence for the exact same offense. And that's where the problem is. And then we also have discrepancies from one county to another. So what we really need is some sort of standard, universal standard in California. And part of the problem is that the taxpayers are fitting the bill. So it's about $100 million a year that will be saved for decisions that are made in other counties, and the discretion has just gone too far, because we are having these individuals having life sentences for stealing a DVD from a store. And that's just simply not affordable anymore, and it's not really what the intent of 3 strikes was originally and what the public believed they were voting for.
And that money, that $100 million a year, I assume would be used for realignment, moving the prisoners from state prisons to county jails. That could be used for that.
Right, it could be used for that, but it also could be used for education, both K through 12, for our university systems. I mean, in our budget crisis. We really have to make sure that we're spending our money wisely, and that $100 million can go a long way. And if we can do that and still have the harshest 3 strikes law in the country, which we still will have after Prop 36, and still punish the worst of the worst with life sentences, then we think the public, wants an opportunity to say that they want this.
I've only got about 30 seconds left in the segment. I wanted to ask you, what are the implications for state prisons and county jails? Where are these new third strikers going to reside?
That will be up to current law, and that will be up to the decisions of the legislature and the governor. They already have systems to identify which prisoners should go into state prisons and which should go into county jail. So that will determine. This proposition does not change that at all.
Well, thank you very much for being here.
Thank you.
When we come back, we'll get a response from those who oppose Prop 36 and want to keep California's 3 strikes laws as it is. That conversation in a moment. This is the Maddy Report. We're now rejoined by Carl Adams, president of the California District Attorneys Association, and opposed to Prop 36. So, some argue that a life sentence for a non-serious or a non-violent offense is too severe. How do you respond?
They're absolutely right.
And that's
3 strikes isn't about that kind of a situation. 3 strikes is a lifetime award. It's like a lifetime achievement award in Hollywood. A guy who's subject to 3 strikes has had a criminal career leading up to a violent armed robbery, rape, or a serious first-degree burglary, residential burglary, a violent or a serious crime for which he's convicted, goes to prison, serves a term, and gets out. And then he comes back, and there's another violent or serious felony crime for which he's prosecuted, convicted, goes to prison, serves a term, and gets out. That guy, if he commits another felony, is
even
subject,
if it's non-serious or non-violent.
Non-serious or non-violent. That guy with that history is now subject to the possibility of 3 strikes. The DA has the discretion to charge it, and if he proves it, the judge has the discretion to sentence it. But that guy with that history, if he shows he still can't live by the community's rules, he's subject to 25 years to life in prison.
Okay, so you say he's earned it.
He's earned it.
Okay.
He's someone who has committed serious violent crimes, and frankly, we don't want to wait for a third victim of a violent crime before he gets the 25 year-to-life possibility.
Okay, but it is for non-violent or non-serious offenses on the
third
third strike.
Can be.
On third strike, okay. How do you respond to the argument that Prop 36 would, one, not alter crimes that constitute strikes, and number two, it wouldn't weaken the law as it relates to rapists, murderers, and child molesters?
Well, let's take those separately, Mark. The fact that it doesn't change what would constitute strikes, it's kind of irrelevant. There's a lot of things that it could do that would be even worse. I don't give it much credit for not being as bad as possible. We're talking about just the third strike. And that brings us to the rapists, murderers, child molesters. See, the people who are supporting Prop 36 admit that there are some people whose previous history is so bad that they should go to prison on the third strike, even if it's nonviolent, non-serious. They think it should be limited to rapists, murderers, child molesters. I think that anybody...
But those are serious and violent crimes, obviously.
They are. But there's a lot more serious and violent crimes than those three.
Can you give me an example?
Armed robbery.
Okay.
Using a gun in a liquor store.
And under this...
Rape of an adult.
Okay, but in this proposition, to be clear then, that would change that? That would be considered a non-serious, non-violent...
It wouldn't change it. It has to do with that third strike. My position is that the third strike should apply to anyone who has 2 prior violent or serious felony crimes in their history. The proponents say those violent and serious felony crimes should be rapes, murders, or child molests before the third strike can be nonviolent.
Okay. They also say that, you know, this is kind of, it's too costly, that the 3 strikes is very costly. You know, cite the example of it's about $50,000 a year to house a prisoner. More money is spent on state prisons than state universities. Is 3 strikes too costly?
No. Locking people up is costly. Incarcerating people because they commit crimes is an expensive proposition. But we have decided as a society that the people who break our rules and are a threat to others should be locked up and separated. That's what 3 strikes is about. Is it expensive? Yeah. But we've made a decision that incarceration is the way we're going to protect ourselves from these people. And it works. The other aspect of it is that having these people loose in the community has been shown to be far more expensive economically by studies all across the nation. It's more expensive to have burglars and robbers and drug dealers in the community than it is to have them locked up. Economically, putting them in prison is a good deal.
So how many people are we talking about here that are, you know, at that third strike level? I think I read a statistic somewhere, it's about 8,000?
8,000 or 9,000.
People are serving
that. That's the total population of 3 strikers. That's not just the 3 strikers that have a non-violent strike. Remember, a lot of these people have 3 serious and violent strikes.
Right.
And that's what the bulk of the 9,000 is made up of.
Okay. I don't have that statistic, so but I knew that about 8,000 were subject to the 3 strikes. What would you say to the argument that county DAs handle 3 strikes differently? Some rarely impose it, others impose it quite regularly. Shouldn't law be applied consistently?
Yeah, it should. We have a process in California that elects a district attorney in every county. And the district attorney of Modoc County in Northern California is probably going to see justice for his community a little bit differently than the district attorney of San Francisco County. But there's one state penal code. There's one set of crimes that people can't commit in either location. There's one set of criminal procedures that apply to the trials in both locations. The district attorney is the element that reflects the difference between the communities and lets the community feel that it has justice as it perceives justice in that community.
Well, I want to thank you very much for joining us and all of our guests for joining us. If you want to stay up to date on state politics and local politics, you can sign up for our award-winning e-newsletter, The Maddy Daily, by logging on to our website at maddyinstitute.org.
And now, another perspective.
20 years ago, a career criminal murdered Kimber Reynolds outside a Fresno restaurant. Her father, Mike Reynolds, reacted by launching a crusade to keep repeat offenders in prison for as long as possible. I wrote about Reynolds in 1994 as his 3 Strikes initiative gathered momentum and won at the polls. California's 3 Strikes law is the nation's toughest, though courts have sanded down some of its edges. Proposition 36 on the November 6th ballot would soften it a little more. Reynolds took matters into his own hands. Just as they did in 1994, Californians must answer a hard question. Does his Three strikes law serve the state's best interests. Proposition 34 raises a tougher question. Should California abandon the death penalty and replace it with life in prison without parole? I witnessed an execution, that of Robert Alton Harris, in April 1992, the first in this state after a 25-year court battle. Death penalty experts thought Harris's execution would herald a new era in which executions would become routine. How wrong they were. There are 729 murders on death row, but the death penalty in California is little more than a theory. There have been 13 executions since the death penalty was reinstated, and 84 death row inmates have died of old age, suicide, or drug overdose. There has been a moratorium on executions since 2006, when a federal judge ruled that California's method of execution, lethal injection, might cause undue pain to the person dying. That court fight will end, as it did for Harris, but there will be another issue after that. Death row will grow, costs will mount. Questions raised. Will executions ever become routine? Do we want them to be? Should California end the fiction that we have a death penalty? This has been Dan Morain, columnist with the Sacramento Bee, for the Maddy Report.
The views expressed in the Maddy Report are those of the individuals participating in the program and do not necessarily reflect those of the Maddy Institute, the California Channel, Casey, or Valley PBS. If you'd like to share your thoughts about the points and opinions shared in the Maddy Report, visit our website at valleypbs.org/Maddy.
This has been the Maddy Report. Thanks for joining us.